हेलो एवरीवन। टारगेटेड जुडिशरी चैनल पे आप सभी का स्वागत है। आज के वीडियो में हम इंडियन एविडेंस एक्ट के सेक्शन नंबर 153 से स्टार्ट करेंगे। तो 153 टॉक्स अबाउट द एक्सक्लूजन ऑफ एविडेंस टू कंट्राडिक्ट आंसर टू क्वेश्चन टेस्टिंग वेरासिटी, यानी सत्यवादिता परखने के लिए जो प्रश्न पूछे गए हैं उस प्रश्नों के उत्तरों का खंडन करने के लिए साक्ष्य का अपवर्जन। कैसे कि व्हेन अ विटनेस has been asked and has answered any question which is which is relevant to the inquiry only insofar as it tends to shake his credit by injuring his character, no evidence shall be given in contradict him, but if he answer falsely he may afterwards be charged with giving false evidence. So जब किसी साक्षी से कोई ऐसा क्वेश्चन पूछा गया है जो जांच से केवल वहीं तक सुसंगत है जहां वह उसके सील को क्षति पहुंचाकर उसकी विश्वसनीयता को धक्का पहुंचाने की प्रवृत्ति रखता है, तो उसने उसका उत्तर दे दिया है, तब उसका खंडन करने के लिए कोई साक्ष्य नहीं किया जाएगा। किंतु अगर गलत उत्तर देगा तो उसके ऊपर मिथ्या साक्ष्य देने का आरोप लगाया जा सकता है। एक्सेप्शन फर्स्ट है कि अगर एक विटनेस, इफ अ विटनेस इज आस्क्ड वेदर ही हैज बीन प्रीवियसली कन्विक्टेड ऑफ एनी क्राइम और एंड डिनाइज इट, एविडेंस मे बी गिवन ऑफ हिज प्रीवियस कन्विक्शन। अगर कोई साक्षी से पूछा गया है कि क्या किसी अपराध के लिए पहले भी दोष सिद्ध हुआ है और वो ऐसा करने से डिनाई कर दे, तो उसकी भाई पहले वो इस तरीके से कन्विक्ट हुआ है क्या, उसके लिए साक्ष्य दिया जा सकता है। ये इसका एक्सेप्शन है। सेकंड है, इफ अ विटनेस इज आस्क्ड एनी क्वेश्चन टेंडिंग टू impeach his impartiality and answer it by denying the fact suggested, he may be contradicted. तो यदि किसी साक्षी से उसकी निष्पक्षता पर अधिक्षेप रखने की प्रवृत्ति वाला कोई क्वेश्चन पूछा जाता है और उस सुझाए हुए तथ्यों के प्रत्याख्यान के द्वारा उसका उत्तर देता है तो उसका खंडन किया जा सकता है। इलस्ट्रेशन में गिवन है कि अ क्लेम अगेंस्ट एन अंडरराइटर इज रजिस्टर्ड ऑन द ग्राउंड ऑफ फ्रॉड। किसी निम्नांक के विरुद्ध एक दावे के प्रतिरोध कपट के आधार पर किया जाता है और दावेदार जो है, द क्लेमेंट इज आस्क्ड वेदर इन ए फॉर्मल ट्रांजेक्शन ही हैड नॉट मेड ए फ्रॉडुलेंट क्लेम, ही डिनाइज इट। उसे पूछा जाता है क्या उससे पहले भी उसने व्यवहार में कपटपूर्ण दावा नहीं किया था, वह इसको डिनाई कर देता है। एविडेंस इज ऑफर्ड टू शो दैट ही डिड मेड सच क्लेम। दर्शित करने के लिए साक्ष्य प्रस्थापित किया जाता है कि उसने ऐसा दावा किया था। द एविडेंस इज इनएडमिशेबल, साक्ष्य है वो इनएडमिसेबल है। नेक्स्ट है, witness is asked whether he was not dismissed from a situation from dishonesty। किसी साक्षी से पूछा जाता है क्या वह किसी ओहदे से बेईमानी से काम करने के लिए यहाँ पे हटाया नहीं गया था, वो मना करता है। तो अब एविडेंस है वो यहाँ पे ये शो करने के लिए कि उसको इस तरीके से हटाया गया था, एविडेंस शो किया जाता है। द एविडेंस इज नॉट एडमिसेबल, एविडेंस है वो यहाँ पे ग्राह्य नहीं है। अगला है, ए अफर्म्स that on certain day he saw B at Lahore, or A is asked whether he himself was not on that day at Calcutta, he denies it. Evidence is offered to show that A है वो कलकत्ता में था। Evidence is admissible not as contradicting A on fact which affects his credit, but as contradicting the alleged fact that B was seen on the day in question in Lahore. In each of these cases the witness might, if his denial was false, be charged with giving false evidence. A is asked whether his family has not had a blood feud with the family of B against whom he gives evidence, वो डिनाई कर देता है। He may be contradicted on the ground that the question tends to impeach his impartiality. Next है 154, क्वेश्चंस बाय पार्टी टू हिज ओन विटनेस। पक्षकार के द्वारा अपने ही साक्ष्य से क्वेश्चन पूछना। द कोर्ट में इन इट्स डिस्क्रिशन परमिट द पर्सन हु कॉल्स ए विटनेस टू पुट एनी क्वेश्चन टू हिम विच माइट बी पुट इन क्रॉस एग्जामिनेशन बाय द एडवर्स पार्टी। न्यायालय उस व्यक्ति को जो साक्षी को बुलाता है उस साक्षी से कोई ऐसे प्रश्न करने की आज्ञा दे सकता है कि जो प्रतिपक्षी के द्वारा प्रतिपरीक्षा में किए जा सकते हैं। नथिंग इन दिस सेक्शन शैल डिसएंटाइटल द पर्सन सो परमिटेड अंडर सब सेक्शन फर्स्ट टू रिलाई ऑन एनी पार्ट ऑफ द एविडेंस ऑफ सच विटनेस। इस धारा की कोई भी बात उपधारा फर्स्ट के अधीन इस प्रकार किए गए अनुज्ञात व्यक्ति को ऐसे साक्षी के साक्ष्य के किसी भाग का अवलंब लेने के हक से वंचित नहीं करेगा। 155 टॉक्स अबाउट द इम्पीचिंग क्रेडिट ऑफ विटनेस, साक्षी की विश्वसनीयता पर अधिक्षेप। The credit of a witness may be impeached in the following ways: by the adverse party or with the consent of the court by the party who calls him. First, by the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of credit, and by proof that witness has been bribed or has been accepted the offer of a bribe or has received any other corrupt inducement to give his evidence, by proof of former statement inconsistent with any part of his evidence which is liable to be contradicted. A witness declaring another witness to be worthy of credit may not, upon his examination in chief, give reasons for his belief, but he may be asked his reason in cross examination, and the answers which he gives cannot be contradicted through. If they are false, he may afterwards be charged with giving false evidence. इलस्ट्रेशन में है कि ए है वो बी को सू करता है फॉर द प्राइस ऑफ गुड्स सोल्ड एंड डिलीवर्ड टू बी. सी कहता है दैट ही डिलीवर्ड द गुड्स टू बी. Evidence is offered to show that on a previous occasion he said that he had not delivered goods to B. The evidence is admissible. नेक्स्ट है ए इज इंडिकेटेड फॉर द मर्डर ऑफ बी. सी कहता है कि बी व्हेन डाइंग डिक्लेयर किया था उसने कि ए हैड गिवन बी द वुंड ऑफ विच ही डाइड. एविडेंस इज ऑफर टू शो दैट ऑन ए प्रीवियस ओकेजन सी ने बोला कि वुंड वाज नॉट गिवन बाय ए और इन हिज प्रेजेंस. द एविडेंस इज एडमिसेबल. 156 talks about the question tending to corroborate evidence of relevant fact admissible. सुसंगत तथ्य के साक्ष्य की संपुष्टि करने की प्रवृत्ति रखने वाले प्रश्न ग्राह्य होंगे. When a witness whom it is intended to corroborate gives evidence of any relevant fact, he may be questioned as to any other circumstances which he observed at or near to the time or place at which such relevant fact occurred. If the court is of opinion that such circumstances, if proved, would corroborate the testimony of the witness as to the relevant fact which he testifies. A एक accomplice है gives an account of robbery in which he took part. He described various incidents unconnected with the robbery which occurred on his way to and from the place where it was committed. Independent evidence of these facts may be given in order to corroborate his evidence as to the robbery itself. Next है 157. Former statement of witness may be proved to corroborate later testimony as to the same fact. In order to corroborate the testimony of a witness, any former statement जो उसने पहले किया था made by the witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. Next, 158. What matters may be proved in connection with proved statement relevant under section 32 and 33. Whenever any statement relevant under section 32 and 33 is proved, all matter may be proved either in order to contradict or corroborate it, or in order to impeach or confirm the credit of the person by whom it was made, which might have been proved if that person had been called as a witness and had denied upon cross-examination the truth of the matter suggested. Next is 159. Very important, asked many times. Refreshing memory. A witness may, while under examination, refresh his memory by referring to any writing made by himself at the time of the transaction concerning which he is questioned, or so soon afterwards the court consider it likely the transaction was at the time fresh in his memory. The witness may also refer to any such writing made by any another person and read by the witness within the time aforesaid if when he read it he knew it to be correct. When witness may use copy of document to refresh his memory. Whenever a witness may refresh his memory by reference to any document, he may, with the permission of the court, refer to a copy of such a document, provided that the court be satisfied that it is sufficient reason for the non-production of the original. And expert may refresh his memory by reference to professional treatise. Next, 160. Testimony to fact stated in document mentioned in section 159. A witness may also testify to facts mentioned in such any such document as in mentioned in 159, although he has no specific regulation of the facts themselves if he is sure that the facts were correctly recorded in the document. A bookkeeper may testify to fact recorded by him in books regularly kept in the course of business if he knows that the books were correctly kept, although he has forgotten the particular transaction entered. And now is 161, right of adverse party as to writing used to refresh memory. Any writing referred to under the provision of the two last proceeding section must be produced and shown to the adverse party if he requires it. Such party may, if he pleads, cross examine कर सकती है witness को. 162, production of documents. A witness summoned to produce a document shall, if it is in his possession or power, bring it to the court, notwithstanding any objection which there may be to its production or its admissibility. The validity of any such objection shall be decided ऑन बाई द कोर्ट. द कोर्ट अगर उसको लगता है सही तो इंस्पेक्ट कर सकती है डॉक्यूमेंट को अनलेस इट रेफर to matters of state or take other evidence to enable it to determine its admissibility. Next इसी में ये translation of document. If for such a purpose it is necessary to cause any document to be translated, तो कोर्ट को अगर लगता है तो डायरेक्ट कर सकते हैं ट्रांसलेटर को to keep the content secret and unless the document is to be given in evidence. If the interpreter disobeys such direction, he shall be held to have committed an offense under section 166 of IPC. 163 talks about the giving as evidence of document called for and produced on notice. When a party calls for a document which he has given the other party notice to produce, and such document is produced and inspected by the party calling for its production, he is bound to give it as evidence if the party producing it require him to do so. 164, using as evidence of document production of which was refused on notice. When a party refuse कर देती है to produce a document which he has not noticed to produce, he cannot afterward use the document as evidence without the consent of the other party or the order of court. A B को sue करता है on an agreement and give B notice to produce it. At the trial, A call for the document and B refuse कर देता है to produce it. A give secondary evidence of its contents. B seek to produce the document itself that contradict the secondary evidence given by A, or in order to show that the agreement is not stamped, he cannot do so. यानी सूचना पाने पर जिस दस्तावेज को पेश करने से इनकार कर दिया था उसकी साक्ष्य के रूप में उपयोग में लाना. जब कोई पक्षकार ऐसे दस्तावेज को पेश करने से इनकार कर देता है जिसे पेश करने की उसको सूचना मिल चुकी है तो वह बाद में उस दस्तावेज को दूसरे पक्षकार की सम्मति के न्यायालय के आदेश के बिना साक्ष्य के रूप में यूज नहीं ले सकता. ये दिया गया 164 में. नेक्स्ट है 165, जज पावर टू पुट क्वेश्चंस और ऑर्डर प्रोडक्शन. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleads in any form at any time of any witness or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor their agents shall be entitled to make any objection to such question or order, nor without the leave of the court to cross examination any witness upon any answer given in reply to any question, provided that the judgment must be based upon fact declared by this act to be relevant and duly proved. Provided also that this section shall not authorize any judge to compel any witness to answer any question or to produce any document which you witness would be entitled to refuse to answer or produce under section 120 to 131, both inclusive, if the question were asked or the document were called for the adverse party. Nor shall the judge ask any question which it would be improper for any other person to ask under section 148 and 149. Nor shall he dispense with primary evidence of any document except in the case herein before accepted. 166, power of jury or assessor to put question. In case tried by jury or with assessor, the jury or assessor may put any question to the witness through or by leave of the judge which the judge himself might put and which he consider proper. Now the last chapter, chapter number 11 of improper admission and rejection of evidence. साक्ष्य के अनुचित ग्रहण और अग्रहण के विषय में 167 एक ही यहाँ पे सेक्शन है चैप्टर 11 में। 167 नो न्यू ट्रायल फॉर इम्प्रॉपर एडमिशन और रिजेक्शन ऑफ एविडेंस। साक्ष्य के अनुचित ग्रहण अग्रहण के लिए नवीन विचारण नहीं होगा। द इम्प्रॉपर एडमिशन और द रिजेक्शन ऑफ एविडेंस शैल नॉट बी ग्राउंड ऑफ इट सेल्फ फॉर ए न्यू ट्रायल और रिवर्सल ऑफ एनी डिसीजन इन एनी केस इफ इट शैल अपीयर टू द कोर्ट बिफोर विच सच ऑब्जेक्शन इज रेज्ड दैट इंडिपेंडेंटली of the evidence objected to and admitted there was sufficient evidence to justify the decision, or that if the rejected evidence had been received it ought not to have varied the decision. So now our all the sections are completed. 167 sections are completed and our Indian Evidence Act is now completed, and I hope this video will help you. So keep watching and keep sharing, and thank you so much. Have a nice day.